From supplementing list for orders we defect item 1 first appeal filing number 12392 of 2024.
Which defect?
Defect with respect to paying the court fee.
Court fee.
Yes, my submission to the person that I am the respondent in the suit. The plaintiff had referred the suit for cancellation of two sale deeds. There is 25-27 decimal of the land. Against that matter, I was the petitioner, the appellant for this one, only claimed 4 decimal. So my only prayer before the by way of to calculate
4 decimal means
4 decimal of land.
the matter relates to cancellation of sale deed.
Of 2 sale deeds.
Maybe 2 sale deeds. Out of that sale deed, you are claiming only 4 decimal.
No, 2 sale deeds. One sale deed belongs to me and another sale deed belongs to other defendant who are not comparable.
So far as your sale deed is concerned, it is
I'm
only
4 point something decimal land.
so. And what is the valuation of your? How do we segregate this value?
So
How do we segregate this value?
since the suit or the
You
plaintiff
see,
has-
at the time of valuation of suit, there is no such concept that
Yes,
it will
but-
be valued property wise.
I was the defendant in that suit. I was the defendant.
That's right.
And now I am claiming only 4 point something
I
decimal.
said, no, it can't be like this. We cannot say segregate the valuation like this. There is no concept of valuation of suit property wise. There is no concept of valuation of suit property wise. Right? We do not know what is the present value of your suit, of your property.
So sale deed.
See, we will not say. There is no bifurcation. And if that be so, maybe that this is first appeal. Maybe that the appeal would lie before the first appellate court.
This is jurisdiction is pecuniary jurisdiction more than
Total pecuniary jurisdiction for the entire suit property. Suppose your suit property is valued only 20,000 rupees. Then the jurisdiction will also vary.
So then this is I will
No, you pay the court fees. We just
I will 2 weeks time we can.
yes. FA number, filing number FA 12392 of 24. One interlocutory application being IA number 12609 of 2014 has been filed, stating that since the appellant is concerned with only one sale deed, therefore only part of the suit valuation and therefore court fees with regard to only part of the suit valuation is required to be paid. This court is of the considered view that at the time of valuation of suit, there is no concept of property-wise valuation, and accordingly, the interlocutory application is dismissed. At this counsel for the appellant raised for how much time?
2 weeks time.
2 weeks time to remove the surviving defects. That is the only defect.
That is the only thing.
उसके बाद तो आपका बाकी होगा ना.
उसका तो आई एडमिट नंबर पड़ेगा एडमिट. Then there is an I first step.
What is the matter?
The matter relates to that the one apartment has filed a suit for cancellation of the sale deed belonging to the petitioner and other partner on the ground that the sale deed belongs to the apartment. And now my
If the defect as pointed out by the office is removed within time, close this case on 16th of July.
From daily list for final disposal item 1 first appeal 43 of 2012.
Lordship. Permits Lordship. We'll start the argument Lordship. 215 onwards Lordship, daily Lordship. Very big case Lordship. What I am submitting. In a whole day Lordship, it will also be difficult for us to assist in lot of property Lordship. We are ready with the brief. No problem with that Lordship.
Is there any other matter fixed for the
आज से हुजूर कर दिया जाए इसको 4-5 दिन जितना लगेगा. So that Lordship in the night we also prepare for the next day. That is also
Each day 250
Yes.
your Lordship.
ठीक है, मेक योरसेल्फ अवेलेबल। एक चीज और है,
हम अवेलेबल रहेंगे
इस तरह के मैटर्स में कोर्ट छोड़ के दूसरा कोर्ट मत अटेंड। दिस आई विल
बीच में नहीं, therefore lordship.
ईदर यू आर देयर और यू आर नॉट
Not, yes.
ऐसे बीच में घुस के कुछ बोलना, उसके बाद दूसरा कोर्ट में चले जाना, इस तरह का प्रोसीजर ये ओनली कोर्ट नंबर 11 में ही चलता
नहीं,
है। दूसरा किसी कोर्ट में करते हैं क्या ऐसा
नहीं होना
procedure?
नहीं चाहिए।
In the midst of the proceeding, you are running to another court. कल को बोलिएगा हम एक बेल करके आते सिविल
I have also experienced lordship in one case. I was appearing the other side, frequently going and coming to the
ये
court.
नहीं, दिस आई विल नॉट।
मेरा तो
एकदम।
ज्यादा
उसके
brief
बाद
नहीं है,
उसके बाद हम
इनका
यही
होगा।
करेंगे, अगर ऐसा कोई जाएगा तो
नहीं,
आई
नहीं,
से
हम-
डोंट कम बैक, डोंट कम बैक।
At least I'll not do it. इनका
नहीं,
थोड़ा
नहीं।
प्रेशर ज्यादा
नहीं,
है।
नहीं।
क्योंकि देखिए जब भी कोई आर्गुमेंट होता है, इट इज वेरी इंपॉर्टेंट दैट यू हियर द अदर साइड,
Yes.
अदरवाइज हियरिंग का
That
क्या
is most
मतलब है?
important.
ठीक।
You have to hear the court's query, you have to hear the other side and then respond accordingly.
Otherwise, reply is not
आप
proper.
मेरा कोई क्वेरी नहीं सुनेंगे, उसके बाद अपने
Reply
स्टाइल
कहाँ से
से
करें?
ठीक है
ऐसा नहीं करिए। सवा 2 बजे सुनेंगे,
ठीक,
देख
ठीक।
दो।
Yes.
ईच डे एट 2
हाँ,
वो
उसको-
आधा दिमाग बोर्ड में नहीं रखना।
बिल्कुल। इसीलिए हुजूर क्या है?
आप
at
यू
the-
मेक योर अरेंजमेंट। ऐसा नहीं है कि दूसरा कोर्ट में आप
215
बोलेंगे कि
जो-
अभी हियरिंग चल रहा है, फिर भी कोर्ट विल पास एन एडवर्स
नहीं,
ऑर्डर।
नहीं, ऐसा।
ऐसा अपने हाई कोर्ट में नहीं होता, ठीक है?
विल
Item 2, second bid 261 of 2017.
Yes.
This is the defendant's second appeal. The substantial question of law was framed by order dated 30/11/2019. May I read it? May I read it?
Yes.
Whether the appellate court below judgment is perverse concerning the exhibits 4 and 4/1, which is registered to in the name of Taki Yadav, who is the ancestor of the plaintiff, and at the same time not considering the exhibit A filed with the defendant, which is the certified copy of the registered to, showing the name of the defendant Balu Yadav, who is the appellant in the second appeal, and thus in view of the matter, the judgment of the appellate court below is perverse or not. However, your ladyship, we are proposing additional substantial question of law in this. Because this will not help us, your ladyship,
That's your problem. We don't know.
for proper adjudication of this case.
Where is that additional substantial question of law?
They prepared an IEM could not be filed because the appellant is 90 years old.
So
He was faced-
you are also 90 years old.
No, I'm not.
For
But he
framing
has-
additional substantial question of law, you
We
need the
have- we
help
have
of the
prepared-
appellant.
We have prepared the IEM. It could not be filed because it could not be notarized because he was not here to sign the affidavit.
So
I'm just
he is 98 years old.
He's 90,
90.
around 90.
So what should be done? Who's for the respondent? कंसेंट लेके आए हैं दोनों, बात करके बाहर से।
नहीं
बात
नहीं ये कुछ नहीं है, बताइए क्या।
नहीं तो इसको हम बस दे दे रहे हैं your ladyship. I will start the argument. If your ladyship
Start the
wants,
argument.
I will start.
And then I will frame the substantial question of law during the course of the argument, and I will decide it on the same day. You think we are fools?
Beg your pardon, ladyship, but
You just tell us what is the procedure for framing substantial question of law,
during the course of hearing, the court can frame the
and then
additional substantial question.
and then a date has to be fixed for answering that question. It can't be decided on the same day. You are not aware of this procedure also.
It's my fault. It's our fault.
देखिए जब एडिशनल सब्सटेंशियल क्वेश्चन, आप लोगों को क्या प्रोसीजर, किनके साथ हैं आप?
Rahul Kumar.
उनको नहीं पता है। अगर आपको एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाना है, अपीलेंट इज नॉट एबल टू कम, अरे भाई अपने क्लर्क से भी कर देंगे, क्योंकि जो भी कुछ होगा वो तो रिकॉर्ड के बेसिस पे होगा ना। रिकॉर्ड के बाहर कोई एडिशनल सब्सटेंशियल क्वेश्चन ऑफ लॉ बन जाएगा क्या?
उनको भेज दिए थे बना के संडे को.
आप मेरी बात ही नहीं समझ रहे। कभी कभी कुछ मैटर्स में वी परमिट इवन द एडवोकेट क्लर्क सेइंग दैट ऑन इंस्ट्रक्शन आई एम फाइलिंग इट, ही इज नॉट एबल टू कम फॉर सम रीजन, क्योंकि सेकेंड अपील में सब्सटेंशियल क्वेश्चन ऑफ लॉ तो बनेगा रिकॉर्ड के बेसिस पे ना, उसके लिए लिटिगेंट को सुनने का कोई ज़रूरत नहीं। And you have to serve to the other side, and he will also have the chance to address, and then if we are satisfied on the basis of the records, we'll frame it. इसमें कोई एफिडेविट में कोई फैक्चुअल बात बताना है क्या? नहीं ना। तब ये सब प्रोसीजर आपके सीनियर आपको नहीं बताते हैं. In compelling circumstances, his best friend, his son, or anybody else can also come. कहाँ का पार्टी है?
एक इंडल्जेंस दे दिया
दे देंगे. 2-3 साल एडजर्न करा देंगे.
आज ही फाइल कर देते हैं.
2-3 साल एडजर्न करा देते हैं आराम से. उसके बाद देखे जाएंगे कौन जिएगा, कौन मरेगा. हम मरेंगे कि वो मरेंगे कि कौन मरेगा. वी डू नॉट नो. 90 इयर्स हैं. ठीक, हमको याद है इस केस को मेंशन कर करके आप लोग लगवाए हैं कि 90 इयर्स ओल्ड. एक केस में मिस्टर राहुल गुप्ता मेंशन करते थे ही इज 90 इयर्स ओल्ड. यही वो मैटर है. मस्ट बी दिस वन.
उसको मेंशन नहीं किया.
अपने से चढ़ गया है.
अच्छा.
गलती से चढ़ गया. रॉन्गली लिस्ट. विद कंसेंट फाइनल डिस्पोजल के लिए फिक्स हुआ था ये. लिखिए ऐसे नंबर 261 of 2017. This case has been listed for final disposal. आप प्लेंटिफ हैं कि अपीलेंट, मतलब कौन?
डिफेंडेंट.
Counsel for the appellant seeks adjournment and submits that a petition is to be filed for framing additional substantial question of law. But the appellant could not come for swearing affidavit. He seeks adjournment. Posed this case on 4th of December under the heading for final hearing. Final disposals are done. कोई काम नहीं है इसमें.
इसको आज ही करवा दें.
मैं कुछ नहीं करना. चलिए करें. इसको इंटरेस्टिंग में काम करने के लिए उसके लिए हम लोग को क्या पड़ा हुआ है? 2017 का अपील पड़ा रहेगा और 2-4 साल
उसको आज
यूजुअल कोर्स में लिस्ट होगा. आपको क्या लगता है टेकअप हो जाएगा?
उसको आज ही
नहीं कुछ नहीं करें. यू डोंट डिजर्व इट.
Item 3, first April 43 of 2018.
हम क्या बताएं? आप इसको इनको ये लेके खड़े हो गए हैं कि हमको अभी दूसरे साइड को कॉपी देना है. क्या करना है? हम लोग वो केसेस में ज़्यादा इंटरेस्टेड हैं जहाँ पार्टीज इंटरेस्टेड, जहाँ पार्टी को मतलब नहीं है अपने केस से, तो हमको क्यों मतलब है?
Only without IA also your lordship these can be
कोई
raised.
बात नहीं. लेकिन आपके काउंसिल ने ऐसा कुछ सबमिशन नहीं किया. चलिए हाँ बताइए इस पे क्या करना है?
day after tomorrow it's being posted. Otherwise I'm ready.
अदरवाइज कैसे रेडी हो सकते हैं? When you want substantial question of law to be framed.
So allow me to start my argument.
आपको समझाए समझ में नहीं आया. जब तक सब्सटैंशियल क्वेश्चन ऑफ लॉ फ्रेम नहीं होगा एडिशनल, उसके बाद फर्दर हम टाइम नहीं देंगे. हम इस केस को नहीं डिसाइड
I will
करेंगे.
file it today itself. आज ही फाइल करवाऊंगा. इसको day after tomorrow.
छोड़ दीजिए ना, क्या जरूरत है?
एक इंटरव्यू लास्ट इंटरव्यू आज फाइल करवा.
ठीक है, डे आफ्टर टुमारो कर दीजिए अंडर द सेम. अदर साइड है उनके एब्सेंस में तो नहीं होता. कॉपी सर्व करिए उनको. तो परसों छुट्टी है, आप आ रहे हैं क्या?
Monday.
ये
Lordship, on the
Time
last
of
occasion there was record was called for from the state side. I haven't got the record. Yesterday.
प्लीज टाइम मत. बहुत छोटा सा आपका
Tell me,
point.
mami, मतलब इसमें 8 आदमी का डेथ हो गया. File, I will make the ready petition, death certificate with the Aadhaar.
Legal years लीगल ईयर्स का डिटेल है कि नहीं?
Yes, yes. सारा डिटेल दिया है, उनका
वकालतनामा
आधार
उनका?
कार्ड भी दे दिया है।
वकालतनामा?
वकालतनामा रेडी है, लेकिन हम इंफॉर्मेशन भी है, अदरवाइज दे हैव टू फाइल अ पिटीशन. वकालतनामा इज रेडी विथ मी, बट
All the वकालतनामा?
Yes.
Of all the legal years?
yes,
आपको कितना टाइम लगेगा मुझे?
I will inform them.
2-4 लोग और मर जाएंगे. कब का एक्विजिशन है? कब से आप इस जमीन पर हैं? बताइए. 87.
86, 87.
हाँ.
86.
तो
As
आपका
my
जन्म हो
lord,
गया था
as
86.
my
Were you
lord,
born in 86?
as my lord better it. I will
एक
inform
हफ्ता
my-
में फाइल करिए. लोकल मैटर है, बुलाइए किसी को.
दानापुर पटना से.
दानापुर पटना से आने में कितना टाइम लगता? 8 घंटा.
1 week में at my lord better.
आप फाइल कर दीजिए. कॉपी सर्व कर दिए.
yes, to the state and the union.
FA number 43 of 2018. One interlocutory application has been filed. After serving copy on the other parties under order 2210 capital A of CPC. Bringing on record the legal heirs and successors of respondent number 4, 5, 17, 22, 32, 38, 45 and 49 who are said to have expired during the pendency of this case.
Detail of them has been mentioned.
The details of the legal heirs and successors have already been mentioned in the interlocutory application. The learned counsel appearing on behalf of the private respondents has submitted that he is already in possession of wakalatnama on behalf of the legal heirs and successors. Once the petition for substitution is filed on behalf of the appellant, the case can easily progress. Counsel for the appellant submits that the matter be posted on next Wednesday, Thursday को आपका सब्स्टिट्यूशन अलाउ करेंगे और आप उस दिन अगर चाहें तो थोड़ा आपसे सुन लेंगे और बाकी फ्राइडे को डिसाइड करेंगे. ठीक है?
Ladyship, one request.
Next Thursday. Yes.
If my ladyship is keeping the records, can I have it for some time so they can get a photocopy of it?
Yes, please.
Or maybe I can submit it on the next day. If
रिकॉर्ड हमको देखना होता है.
हम ठीक है, हम आज ही दे देंगे.
फोटोकॉपी आज ही नहीं, मतलब मंडे को दे दीजिए. ठीक है?
दे
आप ऐसा करिए ना, पूरा रिकॉर्ड का आप ओरिजिनल अपने पास रखिए, एक सेट फोटोकॉपी कर लीजिए. ठीक है?
ठीक.
The counsel for the state has produced the connected records in original before this court, which has been handed over back to him, and he undertakes to file a photocopy of the entire records before this court by Monday. Okay? And he shall retain the original with him. आप soft copy provide कर देंगे? एक.
I'll try to let
He also a soft copy of the same we also provided. आप लोग को चाहिए? नहीं चाहिए, आपका तो छोटा सा. हाँ.
इसमें क्योंकि अवार्ड के अलावा पूरा प्रोसीडिंग जो ऑफिस रिकॉर्ड्स है वो भी
इसमें
That
कोई
is not
secret है क्या?
Exhibits,
That is-
evidence, claim petition, and
Is it a
and
secret?
objection.
No, it is not a secret. जो कोर्ट जो डिपार्टमेंट का जो अपना प्रोसीडिंग्स है वो भी इसी
वो
में
भी
next है. वो
Initial-
इसी में नेक्स्ट है, तो हम टोटल का ही दे देंगे.
हाँ, टोटल का ही दे देंगे, उनको सॉफ्ट कॉपी प्रोवाइड कर देंगे आप. या ऐसा करिए कि इसका हम लोग स्कैन करवा लें. हम लोग स्कैन करवा लेंगे, राइट? और शाम तक आपको वापस भी दे देंगे. ठीक है ना? ठीक है. The records has been handed over to the court. Office is directed to get the entire record scanned and hand over the original back to the learned counsel for the state. However, he shall retain the same और रेफरेंस ड्यूरिंग द कोर्स और आप इनको सॉफ्ट कॉपी पेन ड्राइव में दे देंगे, तो उसके लिए कुछ ऑर्डर करने की जरूरत नहीं।
फोटोकॉपी वाला ऑर्डर तब नहीं होगा।
हाँ, फोटोकॉपी नहीं हमको लगेगा इसमें, वही लोग करा देंगे।
नहीं वो तो स्कैन
Scan.
है, एक कॉपी में उसको दे देंगे।
आप ही करवा लेंगे, ज़्यादा तो है नहीं। स्कैन करके एक प्रिंट निकाल के रख दीजिए, क्योंकि वो जरूरत पड़ेगी।
Item 4, second appeal 48 of 2023.
Yes, appellant.
This matter, there is a money suit that was filed back in the year 2005. The appellant, the BCCL, had taken an insurance policy from the respondent company. That insurance policy was specifically for incoming stores consignment. Thereafter, Your Ladyship, and we had paid a premium of 2,75,501 rupees to them. We never, and the policy duration was up till 26/4/2006. We never utilized the policy. Hence, we claimed refund of the premium that we had advanced to them. Now, Your Ladyship, thereafter we filed a money
If you
suit.
do not utilize the policy, are you entitled to refund?
Your Lordship, there is a clause in the agreement which says that, if I may draw Your Lordship's attention to it.
Let's see the substantial question of law.
Yes. Your Lordship, the substantial question of law was framed on 29/4/2025. Whether the learned first appellate court was justified in framing point of determination number 1, that is whether the suit has been signed, verified and instituted by a duly authorized person in spite of there being no specific objection from the side of the defendant on this ground. Second question of law was whether otherwise also the finding of the learned first appellate court that the suit was not signed, verified and instituted by a duly authorized person is perverse. Third, whether the learned first appellate court has failed to consider that the burden of proof as to dispatch of insured articles by the plaintiff during the insured period was upon the defendant, who miserably failed to prove that the plaintiff appellant dispatched any material during the aforesaid period. Your Ladyship, the second substantial question of law, if that is answered, then the first automatically gets answered. So first I will be proceeding to answer, place my arguments with respect to the second question of law. If order 29 may be seen of CBC.
Order 29. Yes.
Order 29, subscription and verification of pleading. In suits by or against a corporation, any pleading may be signed and verified on behalf of the corporation by the secretary or by any director or any principal officer of the corporation who is able to depose to the facts of the same. When it comes to Your Ladyship, principal officer, the company law, since this is a corporation and that too a public corporation,
It is a public corporation.
it
or
is a
company?
public company.
Yes.
Apologies. It is a public company. Companies Act is applicable because we have also given the statement that 1956 Act is applicable to us. 1956 Act does not define principal officer, but the Income Tax Act under section 2 subclause 35 defines the term principal officer with respect to company. If I may be permitted to read that.
Section 2.
35 of the
That is
Income
for the
Tax Act.
purposes of income tax.
Your Ladyship, but
Income definitions under income tax will not govern the CPC.
may not Your Ladyship, but even otherwise, it includes a manager. Principal officer used with reference to a local authority or a company or any other public body or any association of persons or any body of individual means Number 8, the secretary, treasurer, manager or agent or authority of the company, association or board. So it includes manager here.
You are referring to section
2 subclause 30.
section 2 subclause
30.
clause 30 subclause 8. Thirty is non-resident.
35. Further, Your Ladyship, there are 2 judgments that I am relying upon to show the fact that manager was competent to depose and verify on behalf of BCCL in this matter.
You see, the definition starts in this act unless the context otherwise requires. So these are the definitions meant exclusively for the purposes of the income tax.
I cannot find any other definition of principal officer in any other place.
There is no other definition.
In
other
Company
place.
Act, I could not find a principal officer.
So you
defined
want to say that
CPC
we can draw it from this because it has been defined somewhere. CPC also does not define the principal officer.
and neither the General Clauses Act defines it. Therefore, since it was in context for company, I have relied on this. Further, Your Ladyship, there is a
Just a
judgment.
moment. Who is the signatory to the insurance policy?
He is also a legal manager, Your Ladyship, and they have also not brought on record anything to show that he was competent. In fact, in the
Legal manager, their legal manager.
yes, in my case, in the money suit,
And
the
who signed on your behalf?
material manager. And on their behalf, in the appeal, the legal manager has signed, and he has also not brought on record any chit of paper to show that he has been duly authorized and otherwise competent. So, if a law is being decided, or if a question is being decided by the appellate court against me, then why there is parity with respect to granting it and allowing the respondent to proceed on that point? In my case, material manager has deposed. In his case, the legal manager has deposed. And he has also not brought on record any chit of paper to that.
One last question. The case was filed by material manager.
Yes.
Through
In the
material
money
manager.
suit. Yes.
Money suit was filed through material manager.
Yes.
He is a signatory to the agreement also.
Yes. I have given a statement in my
Where is that?
money suit.
You know, the insurance policy.
Insurance policy, he was not a signatory.
I'm talking about the insurance policy.
I will just verify that.
Who is the signatory to the insurance policy? Where is the policy?
Policy.
Exhibit.
Exhibit 1 here, edition. Here the deputy chief materials manager was the signatory as well as deputy CM, deputy chief material manager.
And you are the material manager.
And I am the material. Exhibit 1.
The communication, that is exhibit 5, is also addressed to the material manager only. I will look at exhibit 5. Kind attention, Mr. Mihir Chandra, material manager SD. So they are also communicating with the material manager.
Continuously. Further, your ladyship,
Just a moment. Did they respond to your legal notice?
yes, they did.
What is their response and whom it is addressed? You issued a legal notice. This is dated 20th March 2007. Where is the reply to this?
Twenty-three 2007, we issued a legal notice. Prior to that, there were communications. They did not reply to the legal notice, your ladyship, but there were communications. 26/12/2006 was a letter that they had refused.
Refusal is addressed to the material manager.
Yes, exhibit 5, the one that
Kind attention, material manager.
refusal. The last refusal that they said that they will not refund my fee.
Can you read your policy? Can you read your policy?
Yes, insurance policy is exhibit 1.
Can you read it? Read it, please.
Terms and conditions.
Yes.
But I could not follow what.
Read your terms and conditions.
Okay. That's
What all are the broad heads?
the on only got which relevant is as per the rule that is declaration clause, para 6 of plate. And the clause is quoted there.
It's first appeal, right?
It's second.
It's second appeal. So I just wanted to see what is the terms and conditions of communication. Because normally under the any contract, it is mentioned that who would communicate.
I don't think that is. I don't think that is.
You read clause 18, 19, 20, 21.
Very hard to read now. Xerox copies are too small, you cannot read it.
Read it.
It's not readable language.
That is why I want to show. Lens
High
दीजिए.
level.
Lens दीजिए. Insurance.
Yes.
Lens दीजिए ना. Lens
Magnifying
नहीं है आपके
glass.
पास. Magnifying glass. सुनिए.
Anyway,
I'll tell you one thing.
even if that
You are
is,
communicating with him.
even if this point is allowed, the second appeal can't be allowed, and that is section 105. These questions of law are not the substantial for the reason that I assume ladyship will allow 1, 2, 3. Still, second appeal can't be allowed.
I will see that.
Yes.
We'll see that. Do you want to say that this is not substantial question?
No, it's not substantial question now.
We heard you by framing it.
No, but it's no right of audience at that point of time.
So first you argue, you see, if these questions stand against them, they are completely nonsense. Even if whatever be the merit of the case. If the suit
Second
itself was
appeal-
not maintainable.
Second appeal, the ladyship tell this is section 100 subsection 5. Now they can't allow argue, but it is always open for me, and the Honorable Supreme Court also says that if it's not going to be a mere academic discussion,
It is not an academic
for
discussion.
the reason that even if it is filed by a competent person, let us assume that it is filed by a competent person, then what will happen? So question number 3 is first has to be seen, and then 1. That is
Sequence is irrelevant. Once the questions of law have been framed,
yes.
suppose 3 is decided in their favor,
And
but
there
1 and 2 are not decided in their favor. The
sequence,
suit has to fail.
if 3 is
You
decided
will not decide the
against
sequence.
them,
Please don't tell us.
if the 3 is
You will
decided,
not decide the sequence. Which question of law will be taken up first?
so let us there.
Let us see. They have come up with this. So
Yes, yes.
we just wanted to see.
Yes.
You are communicating with him
Yes.
the same authority. The signatory is also not the director of the
That
company.
is the written statement also. Who has communicated that is mentioned.
It is there on the face of the document,
Yes. Yes. So,
right?
so what is
The
there
signatory
that
on that behalf is also not the director
Yes.
of the company.
is,
He is the materials manager.
yes.
Did you raise any objection with regard to
Not
his
in the
authority?
written statement.
No objection was
No
raised.
evidence contrary was proved.
No cross-examination on this point.
No cross-examination also on this point.
No cross-examination
Yes.
on this point. Then how and under what circumstances the first appellate court has framed this point for determination? When what is point of for determination? Two parties they join issue.
Whether this point of determination is not defined in CPC, only the issue is defined in CPC. The issue as per CPC is that one party asserts, the other party denies. That becomes the issue, either issue in fact or issue in law. Has to be answered during the proceeding of the suit. When the matter comes before the first appellate
When it comes to point for determination,
yes, then the first appellate court has to sum up the case. The first appellate court is not required. Then again to answer 1, 2,
from
3, 4,
where
5.
does the first appellate
Whether the
court-
suit is maintainable in present form or not. That is the issue, and that has to be in some way translated in some other manner. That is my argument. The suit
You
is
see,
maintainable
the suit-
or not in its
The
present
suit
form.
may not be maintainable for want of pecuniary jurisdiction,
Yes.
for want of territorial
Yes.
jurisdiction, for want of maybe arbitration clause.
Yes.
Maybe there, when the issue is framed whether the suit is maintainable or not, then that has to be seen on in the light of what the parties have actually exchanged their pleadings with regard to maintainability. Right? So you never exchanged any objection with regard to maintainability of the suit qua the status of this person filing the suit.
That is not the point
That is not
raised
the
in
point
the
raised. So therefore, the court getting into the issue that he was competent, not competent, authorized, not authorized, this is beyond the frame of the suit.
That's why I answer this variability. Even if the question of limitation is not raised by anyone. the court
Question
will-
of limitation,
and-
there is a statutory mandate.
whether the court has to see, because this question court is bound to answer even if the other party does not file.
Yes.
For the reason that tomorrow if some order will come, whether the company will be bound by it or not, or the company will say it's not binding on me because it's a judicial proceeding.
That's right.
If somebody goes and says I am representing X, it is to the court to get it satisfied that X is being represented, and even if there is a collusive, just for an example, two officers of two companies collide with each other, and there is a so therefore it is the duty of court to see prima facie whether this is fulfilled or not. And in looking in this aspect, whether the learned court has got something in depth which was not required to be seen, that's a separate issue. But merely for the reason that the defendant has not raised objection does not mean that the plaintiff who was not otherwise competent has become competent person before us. So it was the duty of the court to see, and to what extent it can be, that depends on the facts.
That's all on this. On this question of law, that is sufficient from your end. You were supposed to cite a judgment, you were citing.
This is in Orissa High Court litigation. Page 16, you see. A Supreme Court judgment has been relied upon. Union Bank of India versus Naresh Kumar and others, reported in AIR 1997 SC3, dealing with similar question with respect to suit filed by a public sector bank. The Honorable Supreme Court has stated, in cases like the present where suits are instituted or defended on behalf of public corporation, public interest should not be permitted to be defeated on a mere technicality. Procedural defects which do not go to the root of the matter should not be permitted to defeat a just cause. There is sufficient power in the courts under the Code of Civil Procedure to ensure that injustice is not done to a party who has a just case. As far as possible, a substantive right should not be allowed to be defeated on account of a procedural irregularity which is curable. It cannot be disputed that a company like the appellant can sue and be sued on its own name. Under Order 6, Rule 14 of the CPC, a pleading is required to be signed by the party and its pleader, if any. As a company is a juristic entity, it is obvious that some person has to sign the pleading on behalf of the company. Order 29, Rule 1 of the CPC, therefore provides that in a suit by against corporation, the secretary or any director or any principal officer of any corporation who is liable to depose on the facts of the case may sign and verify on the behalf of the company. Order 6, Rule 14, together with Order 29.1, Rule 1 of the CPC, it would appear that even in the absence of any formal letter of authority or power of attorney having been executed, a person referred to in Rule 1 of Order 29 can, by virtue of the office he holds, sign and verify the pleadings on behalf of the corporation. In addition, there D holds Order 29, Rule 1 of CPC. As a company is a juristic entity, it can duly authorize any person to sign the plain or written statement on its behalf, and this would be regarded as sufficient compliance with the provisions of Order 6, Rule 14 of the CPC. A person may be expressly authorized to sign the pleadings on behalf of the company, for example, by the Board of Directors passing a resolution to that effect or by power of attorney. In absence thereof, and in cases where pleadings have been signed by one of its corporation, can ratify the action of its officer in signing the pleading. Such ratification can be expressed or implied. The court, on the basis of the evidence on record and after taking all the circumstances of the case, especially with regard to the conduct of the trial, come to the conclusion that the corporation had ratified the act of signing by the pleading of its officers. In the matter of an order of this court, the Honorable Supreme Court of Emico Elecon versus Mahanadi Coalfields and others, considering the merit of such submissions, passed an order stating as follows: the special leave petition has been filed against an order dated so and so, dismissing the petitioner's writ petition on the technical ground that the sales manager Debashish Mitra was not competent to represent the company. The matter was not heard on merit. Having regard to the fact that the respondents are duly authorized without disturbing the order of the High Court, we grant leave to the company to file a writ petition on the same cause of action through its duly authorized representative. The next paragraph is important, Your Ladyship. Hence, in certain situations, in public interest, a strict adherence to the rule of filing of proceeding, a suit or a writ petition can be relaxed, especially when the public interest is involved. So, therefore, by allowing me under the CPC to file additional documents, this could have been ratified, Your Ladyship. It was a mere technical issue, but I was not given a chance to either defend or put up my case in this regard, Your Ladyship. Especially when the defendant in the appeal had also not filed any document saying that he was competent to file the appeal itself. This issue was never raised before the title money in the first trial court. Only in the first appellate court, the point of determination was framed, not granting an opportunity of hearing. So there is a violation of the basic principles of natural justice also, Your Ladyship, for not permitting me to defend my case. Just a moment. This is the judgment you are relying upon. This is the provision of law you are relying upon. Let me capture your argument and then I will give you response. I have one more judgment regarding managing authority having authority to sign the document. Page 14 of the judgment, Your Lordship. There is no running page to this.
That is on top, second
Page.
line on top.
Page 12.
SCC online and then the page number.
Okay, yes, yes. Page number 14.
12. This is with respect to Section 211 of Indian Companies Act 1913, Your Ladyship, but they have discussed what an officer would be. at the last paragraph of that page. In the matter of service, we are concerned with Clause A of Order 29, Rule 2, which provides that summons may be served on the secretary or any director or any principal officer of the corporation. What we have to see is whether service on the managing agent whose service was service on other principal officer of the corporation. Section 211 of the Indian Companies Act, which was in force at the relevant time, defines officer to include any director, managing agent, manager, or secretary. So, a managing agent of a corporation is an officer of the corporation. The question then is whether he is a principal officer, and the answer to our mind is obvious considering the nature of the duties of a managing agent of a corporation. It is not seriously disputed either that if a managing agent is an officer of the corporation, he would consider the nature of his duties be a principal officer. What is, however, contended is that the definition of an officer given in the Companies Act is an artificial definition and is only for the purposes of the Companies Act and not for the purposes of the Code of Civil Procedure. The appeal court did not accept this contention as was of the opinion that the definition of an officer given in the Companies Act can also be utilized for the purpose of the Code of Civil Procedure, and we think that that view is correct. Therefore, when the service in this case was effected on the managing agent of the mills, it was effected on one of the principal officers of the corporation and would be good service under Order 29 Rule 2. But it is contended that the intention behind Order 29 Rule 2 is that the service must be on a human being, and that the Order 29 Rule 2 does not contemplate service on one corporation for the purpose of securing service on another corporation. In this connection, reliance is placed on Rules 1 and Rule 3 of Order 29, where it is urged that the same words occur, and it is clear that these rules contemplate that the other principal officer mentioned therein must be a human being. The contention was urged before the appeal court and was rejected by it, in our opinion, rightly. It is true that under Rule 1 and Rule 3, the principal officer envisaged must be a human being, but the conclusion follows from the setting in which these words appear in these two rules. Rule 1 relates to the signature and verification of a pleading by the secretary, director, or other principal officer of the corporation, while Rule 3 provides that a court may require the personal appearance of the secretary or a director or other principal officer of the corporation. It is obvious, therefore, from the setting in which the other principal officer appears in these two rules that he must be a human being for signature and verification in one case and personal appearance in another case only to be a human being. But Rules 1 and 3 do not define who the principal officer is. Therefore, even though in these two principles, a principal officer must be a human being, it does not follow that in Rule 2 it must not be a human being.
Now, you see, whether a person would fall under the meaning of principal officer or not, that itself is essentially a matter of evidence. Had they objected, there was some scope for any ratification, and had they objected, you could have proved that you are the principal officer. In your affidavit, in the plaint, along with the plaint which you filed, you say that you have been duly authorized to.
I have stated.
And there is no cross-examination on this. So, principal officer having not been defined, that does not mean that you are not a person completely alien to it, and the documents are also addressed to you. And therefore, it cannot be said you are not aware with the facts and circumstances of this.
And I have stated my designation clearly that I am the material manager in the.
This is your act.
Yes.
Just a minute. Okay. Second appeal number 48 of 2023. This appeal was admitted for final hearing by order dated 29/4/2025 on the following substantial question of law. The learned counsel for the appellant has addressed the substantial question of law number A and B simultaneously and has submitted that both the issues are related to each other. The learned counsel submits that the appellant is a public sector company and the suit was filed through the material manager, stating that and the plaint itself was filed on affidavit, stating that Priya Ranjan was the material manager of the plaintiff company and was authorized to file the suit and was well acquainted with the facts and circumstances of the case. The learned counsel submits that a written statement was filed. Although an objection was raised that the suit was not maintainable either on law or in facts, but no objection was taken in connection with the locus of the material manager to file the suit. The learned counsel submits that the said person had also deposed before the court as PW1, and there has been no cross-examination of this witness with regard to his authority to file the suit. The learned counsel submits that the parties did not join issue with regard to locus of the material manager to file the suit at the stage of trial, and accordingly no such issue was framed. However, the learned first appellate court has framed the issue of competence of this authority to file the suit and has decided the same against the appellant. Consequently, the appellant has been non-suited. The learned counsel has referred to Order 29, Rule 1 to submit that in suits by or against a corporation, any pleading may be signed and verified on behalf of the corporation by the secretary or by any director or other principal officer of the corporation who is able to depose to the facts of the case. The learned counsel submits that the term principal officer has not been defined under CPC, but the material manager would certainly fall within the meaning of principal officer, as he was duly acquainted with the facts and circumstances of the case and was certainly an officer of the company. The learned counsel has also referred to the documents exhibited before the court, which were undisputed documents on record. Particularly exhibit
5, where communications
5.
have been made to the material manager.
And submits that even the defendant has been communicating with the company through the material manager. The learned counsel has further referred to the learned counsel has submitted that the counsel could not find out any other statute or even under the General Clauses Act defining the term principal officer, and she could get the definition under Income Tax Act 1961, which defines the term principal officer under section 2 within bracket 35, which is quoted as under. The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court. Nay, just first by Honorable Odisha High Court in writ petition number 6068 of 2009 and has referred to paragraph 16. Para
21 and 22.
para
21 and 22.
para 21 and 22 of the said judgment, which refers to, which inter alia refers to judgments passed by Honorable Delhi High Court and Kolkata and Honorable Supreme Court. And has in particular referred to the quotations recorded in the said judgment taken from the judgment reported in AIR 1997 SC 3. The Learned Counsel has also submitted that. In the said judgment, that is AIR 1997 SC3, it has also been observed that a person may be expressly authorized to sign the pleading on behalf of the company through the board of directors by passing a resolution to that effect, or by a power of attorney being executed in favor of individual, and in absence thereof, and in cases where pleadings have been signed by one of its officers, a corporation can ratify the said action of its officers in signing the pleadings. The Learned Counsel submits that the Learned Counsel has thereafter referred to the judgment passed by the Honorable Supreme Court reported in 1961 SSC Online SC 2777 at page number 12 to submit that the said judgment was relating to the service of summons, which has similar provisions as that of Order 29 Rule 1 and is incorporated in Order 29 Rule 2. The Learned Counsel submits that in the said case, it has been noted that Order 29 1 and 3 do not define who is a principal officer. And in the said case, the notice was served upon managing agent, and the Honorable Supreme Court held that considering the nature of duties of the managing agent of the corporation, it must be held that he was the principal officer. the learned counsel submits that the nature of duties assigned to material manager in order to be a principal officer is essentially a matter of evidence. Had any objection been taken with regard to the status of the material manager to file the suit itself, or any such query being raised at the stage of cross-examination, this aspect of the matter could have been answered. She submits that whether a person will constitute a principal officer for the purpose of the company to file a case is essentially a question of fact and not a pure question of law, and such a point requires evidence, and therefore such a point of determination could not have been formulated by the learned first appellate court without foundational legal evidence. That's all.
So far as question number A and B is concerned, the first line to that is that the learned appellate court has not non-suited the appellant. It has answered two questions. First with respect of competence and second with respect of merits of the case. So far as the competence is concerned, it is the duty of the court at least to get it prima facie satisfied that it's a suit by a competent person. In view of section 103 of the Evidence Act, which says that if a particular person wants the court to believe something, it is their duty to. The burden of proof to
Section 103
3, that the burden of proof,
of Evidence Act.
yes, the burden of proof as to any particular fact, he says he is authorized, lies on that person who wishes the court to believe in its existence. It is provided by any law that the proof of that fact shall lie on a particular person, unless the law, just like resumption of dowry death, unless that is there, it is them to prima facie at least satisfy the court that they are the competent person. Then the second aspect of the matter is that even in the evidence what they have adduced, there was no averment that he is a competent person. Because para 1 says that I am authorized for giving evidence. I am authorized to bring the suit, a cause of action on behalf of company. That is not the evidence there. And
Just
in the plate
please hold
also,
on.
evidence may read
I'm not picking.
para 1, मैं प्रिय रंजन कुमार सचिन सच शपथ पूर्वक मैं वर्तमान समय में BCCL के मुख्यालय में कार्यरत हूँ। BCCL की ओर से गवाही देने के लिए प्राधिकृत हूँ। So authorized to give evidence, but whether authorized to sign the pleading of the or his statement will bound the company or not, that is not the evidence. So my submission is, I have no occasion to deny your authority for the reason it's not a part of pleading. Affidavit, now kindly see the plaint. Plaint, there is not given a single averment that I am the authorized person. Affidavit something, the WS can't say that the statement made in affidavit of the plaint at para 2 is false. So that is my second argument. Kindly see the plaint. In the entire plaint, there is no whisper that I am the authorized person or I am authorized to file suit on behalf of the company. I am just verifying again.
In affidavit, he has stated in the first paragraph.
And the affidavit I am not supposed to respond by way of my written statement. So the foundational fact that even a touchstone satisfaction that somebody who is saying himself to the person competent to put forward cause of action of a particular company or organization. May I read that plaint itself? It's entire, because ultimately for answering all these, this plaint is required to be seen. That the plaintiff, Mrs. BCCL, is a central government company within meaning of 617 of the Indian Companies Act, having registered office at such and such, such and such. That the plaintiff is a juristic person and thereby is competent to sue on its behalf. Next. That for this administrative function, plaintiff is divided into various segments commonly known as areas. That the plaintiff concluded an open marine insurance policy, special declaration policy in land for incoming store consignment for all areas of such and such, the policy details. That the total premium is of 2,75,501 was paid by the defendant by check number such and such. After realization, a check, a policy was issued by the defendant to the plaintiff by policy number such and such. Period of is 27/4/2005 to 26/4/2006. That beside other condition, the said policy contains a declaration clause which is quoted below. Now, declaration, it is hereby agreed that the insured will record full particulars of each dispatch in a declaration statement in a chronological order, assigning declaration number for each such dispatch. A copy of statement is completed, should be posted to the company for every fortnight during the first week of the following fortnight. Then the details of declaration. That there was no dispatch. I will only say my entire case is paragraph 6-7. Later on, I will argue on minutes. That there was no dispatch of material attracting coverage under open general policy. Hence, as for the contract, no declaration was given to the plaintiff to the defendant during the currency period. That the subject matter insured has never imperiled, and further no declaration as per contract was given to the plaintiff to the defendant during the currency of the contract. Therefore, entire premium amount of the policy in question is returnable to the defendant, is bound to be refunded premium. That the plaintiff has all along requesting the defendant through several letters for refund of premium of such and such. The defendant lastly refused to refund premium of such and such. That the refusal to refund return premium by the defendant is in violation of condition of such and such. That the plaintiff sought through their panel advocate a legal notice dated such and such to the defendant requesting them to refund the premium of such and such. The said legal notice was sent by registered post, prepaid and correctly addressed to the defendant. That in the premises of aforementioned, the suit is being filed for recovery of premium amount refundable and returnable to the defendant. That the cause of action arose of such and such. That for the purpose of court fee jurisdiction, the suit is valued on such and such. The plaintiff therefore prayed for declaration of suit. Now, I am supposed to transverse anything which is plain. I am not supposed to answer a written statement to answer something which is on very, at least a bare statement in the plaint that the plaintiff is an authorized person. That is not there. The evidence, bare minimum requirement, that is not there. And thereafter, section 103 of Evidence Act, it was their duty. And therefore, whether the suit is maintainable or not, the leadership has put a question how this was. So this is also one of the aspects. 3 questions were framed by the first appellate court with respect of filing of suit, the maintainability of claim, and for any other relief. If the first appellate courts.
No, you just stick to this.
Yes. So on
This
these grounds, I have to say that
With
the court
respect to substantial question of law number 1 and 2, the learned counsel for the respondent has submitted that from the perusal of the entire plaint, there is no averment that the material manager was competent to file the plaint. And merely because it is written so.
not material manager. This particular person is authorized, whatsoever his designation, whether this Person,
material manager or the person who had filed the suit. Who was the material manager at the relevant point of time of the appellant was competent to file the suit. Except and the affidavit appended to the plaint has no relevance. Has no relevance. As the defendant has to respond
my
only to the
submission
plaint.
is the written statement is supposed to answer the
आप
statement.
आधा चीज मत सुना करो, please hold on. And the statement made in the affidavit appended to the plaint has got no relevance inasmuch as the defendant is only to answer to the averments made in the plaint and not to the affidavit and verification. The learned counsel submits that it is certainly open to the court to see as to whether the plaint as such was maintainable or not, irrespective of any specific objection being raised by the defendant. The learned counsel has submitted that, has referred to section 103 of the Evidence Act to submit that the burden of proof as to a particular fact that the then material manager, Mr. Priya Ranjan, was competent to file the plaint was upon the plaintiff, and this burden was never discharged. And therefore, the point was already taken that the suit was not maintainable. This point was not properly addressed by the learned trial court, and therefore the learned first appellate court has framed specific issue with regard to competence of Priya Ranjan, the material manager, to file the suit, and the same has been decided in accordance. The learned counsel has also referred to the evidence and has submitted that at the stage of evidence, the said person, Mr. Priya Ranjan, had deposed, and he has simply stated that he was competent to give evidence, but no statement has been made that he was competent to file the suit. And therefore, in absence of basic averment and evidence with regard to his competence to file the suit, the first appellate court has rightly decided the issue. Bas? Second substantial question.
Ganesh, I just want to respond once to
You
one.
respond.
Just a second. With respect
you
of
respond.
those two judgments, I have to say, those two judgments are with respect of writ proceeding, where a particular paragraph was referred saying so that the court in larger public interest can relax those things. Those observations will not apply to the proceeding under
The learned
CS.
counsel has also submitted that the judgments relied upon by the appellant has no applicability to the facts and circumstances of this case in view of the fact that in paragraph 22 of the judgment passed in the case WP 6068 of 2009 by Honorable Odisha High Court,
Says a suit or
it was held that in certain situation in public interest, a strict adherence to rules of filing or procedure in a suit or writ petition can be relaxed, especially when the public interest is involved.
And
The learned
the
counsel
trial
submits
court-
that in the present case there is no public interest as such involved. It is a litigation between two companies.
And the trial court has not relaxed on this ground their evidence.
The learned counsel has submitted that no order of relaxation has been as such passed by the learned trial court
While decreeing
on this technical aspect of the matter.
Ganesh, if order 29/1 may be read for once, it says in suits by or against a corporation, any pleading may be signed and verified on behalf of the corporation by the secretary or any director or other principal officer of the corporation who is able to depose to the facts of the case. It says that I am competent to sign and verify, which I have done. I have signed, I have verified, and in my affidavit I have given a clear statement.
In response, the learned counsel for the appellant has submitted that a closed loop of Order 29 Rule 1 reveals that the principal officer can sign and verify the pleadings. In the present case, the plain was pleading, which was duly verified and signed by the principal officer, by the material manager, and it was supported by an affidavit disclosing his status.
Yes. And state.
And therefore, the argument of the learned counsel for the respondents that only the plaint is to be seen bereft of the verification and affidavit is not correct. The plaint has to be seen along with the affidavit.
It's indirect.
That's it. Third substantial question.
The third substantial question of law states whether the learned first appellate court has failed to consider that the burden of proof as to dispatch of insured articles by the plaintiff appellant during the insured period was upon the defendant respondent who miserably failed to prove that the appellant plaintiff dispatched any article material during the aforesaid period.
What all clauses of the contract is relevant? Clause number?
Please read it.
It is essentially on documents. Clause number?
Your Ladyship, clause number of the mainland marine inland transit insurance open policy, the preamble itself.
The policy is not in dispute. Is it in dispute? What is the period of policy?
Period of policy is your Ladyship. Uh, 27/4/2005 to 26/4/2006.
When did you apply for refund?
It was lastly refused to us on 26/12/2006, but in between there were communications that we had.
Refund refused 26.
Lastly refused on 26/12/2006. Thereafter we issued a legal notice, which was not responded.
The reason for refusal is
That there is no clause for refund and
no, that is not the reason. Look at the document itself.
and also they stated that in view of your purchase order tender document as per our organization guideline, we could not refund any policy premium. However, we remain
Where are
committed to
you
you
reading?
and in
You read exhibit
five.
5. Yes.
Yes.
In view of
Of
your
your
purchase order manual,
Your all orders have been placed on for destination basis, resulting in risk since the goods were loaded on railway wagon. In view of your purchase
no,
order,
I don't get it. What does that mean?
this means that they are saying that your goods were dispatched, and since they were placed in your purchase order manual, which they have not brought on record, they have not even asked us to produce it. No documentary evidence was left to that effect. They have only made a verbal statement that in your purchase order manual, the documents, all your orders have been placed on for destination basis.
FOR
FOR is
is
transport
free on rail.
free. Yes, sir.
This is not for destination.
FOR, transport of goods to
On
destination.
FOR destination basis,
Yes.
resulting you in risk since the goods were loaded on railway wagon. They have objection to that effect also, that the goods were loaded on railway wagon. And this is marine insurance.
Marine insurance.
So it covers what?
Your
It
Ladyship,
covers transmission of goods through railways also.
that is what they have claimed, Your Ladyship. But in our case, we have not stated that. We have only it says that details are transferred anywhere in India to different units and camps of BCCL. That is what is covered by
This
this.
is covered by marine insurance,
That is what has been stated in the documents.
which has got
They-
nothing to do with water. This marine insurance has got nothing to do with water. Okay. Let us see the clause. Which clause of the insurance company, insurance policy are you referring to?
Your Ladyship, firstly, I will refer to the exhibit 1 may be seen.
Exhibit 1. Yes, please refer to that.
Exhibit 1, para 7. Refund adjustment of advance premium. For adjustment of premium, reports
You read clause 2 also.
risk coverage. The policy must cover all risks like fire, accident, theft, scratching, shortage and rain, etc. The risk covered shall be from the dispatch point to ultimate consignee store, including loading and unloading of the assignment. It should cover the risk by all modes of transportation, whether road or rail, or both, including transition in transport or go down and everything. So everything was
Okay. Then which clause?
the refund 7th clause.
Yes.
Refund adjustment of advance premium. For adjustment of premium, reports must be submitted by the insurance on fortnightly basis. The advance premium, if any, to be refunded after expiry of the policy must be refunded within 15 days of expiry of the insurance policy, failing which interest prevailing bank rate shall be chargeable. So there
You as an insurer were supposed to make insurer for adjustment of premium, reports must be submitted by the insurer
yes,
on fortnightly basis. So who has to submit this? You are the insured.
I am the insurer agent.
They are the insurer.
Yes.
So report on fortnightly basis by them.
This is, I think it is a mistake in this because refund or adjustment of premium would have been sought by us only. This,
I read as it is.
but I am relying upon the second part of it, which says that there is a refund clause. There
There is a refund clause, but it is preceded by a condition also. You just tell us one thing, a very absolutely common sense. If there is an insurance company and they are insuring you for something, and if you do not claim for the entire year or the entire period, your insured premium amount will be refunded.
it will not be a leadership, subject to whether or not there was a clause to that effect. Here, there is a refund clause. Apart from that, there is another clause which says the laws of India at the point of time will be applicable to me. 84.3b gives me that power that I can ask them for the money back. Also, Your Ladyship, there is a doctrine of contra per fortem which says that if there is any ambiguity, in the insurance policy, it has to always be decided in favor of the insured and not the insurer, which is there.
See, so far as
Here there is a clause which says that I can take my refund. I have not utilized the insurance policy. Even if they do not return it completely, they can give me reasons citing saying that okay, these are the reasons, we will deduct this much and proportionately we will return. 84.3b says that also, that proportionately
it talks
may be
about refund of advance premium. What
Yes.
is this advance premium?
that what I have paid to them advance premium
From where do you get this?
2,75,000.
Premium is just premium. What does this advance premium means? What is the meaning of advance premium? Because this is the word I'm hearing for the first time. What is advance premium?
In that plaint, I have made a statement saying that total premium of rupees so and so was paid to the defendant by check number so and so. Accordingly, after realization of the check, a policy was issued by the defendant to the plaintiff.
You see, this clause, marine open policy condition, inland transit insurance. Clause would be 1 within bracket B. It is a condition of the policy that the insured are bound to declare hereunder each and every consignment without exception, company being bound to accept up to but not exceeding the sum insured specified in part 1 of the schedule. So each consignment is required to be notified. That is a very important term of the insurance.
Each consignment income. If I am moving my goods
Income.
within reason. Yes.
When you are moving from one of your depot to another depot, it is all within your establishment only. Have you read this clause?
It was illegible.
हमको तो पढ़ना है, आपको कैसे नहीं पढ़ना?
Copies that we have, it is completely.
My eyes have grown older than you, and I have more power than you. Sure.
It's completely illegible.
प्लस माइनस दोनों हैं. You can't say completely illegible. डॉक्यूमेंट लगाएंगे और बोलेंगे completely illegible. आपको कॉपी ऐसे करो. When we are talking about mutual obligations, we will see these clauses.
It is para 6 of plain.
6 of the plaint.
Plain, therefore I say para 6 of plain. This is the clause on which they are making claim.
Let us
That beside other condition,
let us see para number
6, that beside other conditions, the said policy contains a declaration clause, which is quoted below. Declaration, it is hereby agreed that the insured will record full particulars of each dispatch in the declaration statement in chronological order, assigning declaration number for each such dispatch. A copy of statement so completed should be posted to the company for every fortnight during the first week of the following fortnight. Then next page, the details of declaration statement are date and number, railway receipt, lorry receipt, postal receipt, airway bill, description of goods dispatch, value of goods as specified in part 1 of the schedule, and details of packing. So this they have to give every fortnight to us. And now why this suit? That as there was no dispatch of material attracting coverage, under open general policy. Hence, as far as for the contract, no declaration was given by the plaintiff to the defendant during the currency of
So
contract.
bone of contention would be whether nil declaration is also to be given.
Rule on contention is that how much time they can change their. I am suing that in para 7 of plaint they say चूंकि कभी कोई dispatch हुआ ही नहीं तो हमने आपको intimate किया ही नहीं. Kindly see para 13 of cross examination of this plaintiff कि throughout period हुआ मेरे पास record हम बाद में दे देंगे. Of the evidence. Dinar, the only
Just a moment.
cross examination.
Clause number, para number.
13 and 14. दिनांक 27/4/2005 से 26/4/2006 दिस इज करेंसी ऑफ पॉलिसी पीरियड को के बीच मेरा सामान का स्थानांतरण कई जगह से दूसरा जगह हुआ. डीसीसीएल
एक जगह से दूसरी जगह
आई कांट से डीसीसीएल हेडक्वार्टर में डिस्पैच का कागज है इस पॉलिसी पीरियड के अंदर जिससे पता चलेगा कितना डिस्पैच हुआ यह न्यायालय में दाखिल कर सकता हूँ. सो व्हाट इज देयर केस प्लेट से कि हमने आपको बताया ही नहीं क्योंकि हमने भेजा ही नहीं, इसीलिए सेक्शन 83 में हमको रिफंड 84(3)(b) में हमको रिफंड चाहिए. एविडेंस स्पेसिफिक है कि नहीं हमने भेजा था, आपको नहीं भेजा. यहाँ सेकंड अपील में आर्गुमेंट एंड द क्वेश्चन ऑफ लॉ इज दैट वेदर इट वाज माय ड्यूटी टू एस्टैब्लिश दैट वेदर दे हैव सेंड इट और नॉट सेंड इट. And therefore the section 103 and section 58 that it is contrary, minus by C 58 of the Evidence Act, which says that when there is a contract in writing, parties are not free to say anything contrary to the something which is reduced there. So it was always their duty to give us fortnightly a detailed prescribed report.
So there is a violation of terms and conditions.
And the other aspect that it is not like I'm just otherwise submitting. It is not like that somebody goes and the insurance policy. Actually, a tender is floated. Exhibit 1 is actually a tender invitation where we have participated. It's a by the BCCI. It's an offer expression. What ladyship can say. The company used to give the expression of offer. Then the persons participates. Then policy issues, and after issuance, they will be intimated कि आपको जो policy issue किया गया है, आप अपना policy देख लीजिए. Throughout the currency of the policy, they never raised any objection. And what this refund says that they have to communicate us with respect of refund. Kindly see section 83 of the Marine Insurance Act.
Marine Insurance Act did you? Let her finish. Yes, madam.
Para 5 may be seen on the deposition that I have given.
No,
and
why
para
you will see only
15.
para 5? You admit that there were dispatches.
Your Ladyship, I have said categorically कि चूंकि उपरोक्त ओपन जनरल पॉलिसी की शर्तों को आकर्षित करते हुए किसी सामान का डिस्पैच नहीं हुआ था, इसीलिए वादी की ओर से पॉलिसी अवधि में कोई डिक्लेरेशन प्रतिवादी को नहीं दिया गया. और चूंकि
That is
कोई
not
भी
the case in the
बीमाकृत
plaint.
वस्तु
That is not the case in the plaint. Your case in the plaint is that there was no dispatch and therefore no declaration was
we
given.
have said no dispatch
can be-
attracting the policy.
Just a moment. That is not your case.
It is, Your Ladyship, I have stated that. Yes, I have stated
And-
that.
and you can be selective. You can be selective.
Ladyship, it was an inland policy. Goods that have come from outside have to be insured inside because it says money and insurance policy for incoming stores consignment. Incoming stores consignment.
Incoming from where?
Anywhere in India, it states in
So,
the policy
Your
itself
depot
to
in
different
Ranchi,
units of
your
BCCA.
depot in Ranchi and your depot in Chennai. Both are your depots.
Your Worship,
When
that is
it
not-
goes from Ranchi to Chennai, that is incoming for Chennai and outgoing for Ranchi, and it is your establishment only.
But that is not covered under the policy. It was anywhere in India to BCCL. It may be seen. It is their document, Your Ladyship. Exhibit 1 itself, it says conveyance, road rail, details of transfer from anywhere in India to different units, camps of BCCL. Marine inlet, transit insurance, open policy.
Not part of it.
It is preamble.
That is not exhibited document. You are reading something.
What are you reading?
That is not the exhibit. You please verify.
What's exhibit number 10?
Your Ladyship, right? The preamble, the in marine inland insurance open policy, the preamble itself.
It's not a part of the
It's
record.
not part of
It is not a part of the record.
it. Every insurance is a separate contract subject to marine insurance. Marine.
It is not an exhibited document.
The document I have, Your Ladyship, is the policy number
You
is
keep
given,
it for yourself.
and there is a stamp of ICICI.
That is not exhibited. Exhibit. मुझे आज डिक्टेशन के लिए आज हमने 7:30 बजे को बोला है ना उनको डिक्टेशन करना 4 बजे करेंगे आज ऑर्डर्स नहीं करेंगे 4 बजे उसी का डिक्टेशन करेंगे उनको बोल दीजिए स्टेशन में ठीक है 4 आज ऑर्डर्स नहीं करेंगे But if you have seen the materials, now you just come to the improving elements. Let us see how the court has dealt with it. नहीं है ना उसमें? Maybe insurance company ये नहीं है. Here we are.
My apologies, Your Ladyship. It was the documents, the whole exhibits that were sent to us. That hence I relied upon.
Declaration clause, total value of goods in transit shall be declared on a quarterly basis in the form of a certified statement within a period of 30 days for end of the quarter. Total value of transit is to be declared.
Because the complaint is a separate, the cause of action is changed, the statement is changed. I am reading from the plaint that it's of 10 paragraph. That paragraph 6 is clear that this is the declaration clause, this is the condition. And then very next paragraph they say that since there was no dispatch, therefore no declaration.
That's
There
right.
no dispatch of material attracting coverage and
Where, how do you read additional word to that?
And then say that it has never been imperiled, and further no declaration as per contract was given to the plaintiff to the defendant during
That's right. Let us see the findings.
Yes. Finding the
Trial court decreed the suit.
trial court decreed appellate court reversed.
Let us see the finding of the trial court and then we will see the finding of the appellate. Marine insurance में क्या खोल दीजिए क्या खोल दीजिए ट्रायल कोर्ट
paragraph 10 of the trial court deals with these issues. Since issue number 3, 4, 5, 6, most important issues, and are interrelated as well, therefore, these issues are taken up first for consideration. Admittedly, the plaintiff has concluded an open insurance marine policy, open special declaration policy in land for incoming source consignment for all the areas of the plaintiff company. With the defendant wide exhibit 1, the plaintiff paid rupees 2,75,501 to the defendant as premium, which was acknowledged by the defendant number 4, and therefore the defendant issued a risk assumption letter and policy document exhibit 2 and 3 covering the period from 27/4/2005 to 26/4/2006. Now the contention of the plaintiff is that since there was no dispatch, so this is the case. Now the contention of the plaintiff is that since there was no dispatch of material attracting coverage under open general policy and therefore no declaration was given in terms of declaration clause containing exhibit 3, and therefore it is entitled to get refund of premium amount in terms of section 84(3) of the Marine Insurance Act, hereinafter referred as Act. On the other hand, the contention of the defendant that in view of the purchase order manual and documents, all order were placed for FOR free on railways destination basis, which exposes the plaintiff and the insurer at risk during the transit. When the goods and or consignment are loaded to railway wagon and until it reaches the destination insured store. Further, in view of the purchase order and as per the defendant's organization guidelines, the defendant could not refund premium amount even if for the sake of argument it is assumed that no declaration was given. It does not absolve the risk of the insurer or defendant. Moreover, there is no provision for refund of premium amount in the policy document. Before adverting to the merits of the risk rival contention of the parties, it would be appropriate to have looked to the legal position. Exhibit 3 specifically provides that contracts shall be governed by the law of India, and time being in force, section 84(3)(b) of the Act specifically provides that where the subject matter insured or part thereof has never been imperilled, the premium, or as the case may be, a proportionate part thereof is returnable. Section 86 provides where any right, duty or liability would arise under the contract of marine insurance by implication of law. It may be negative or varied by the expression of agreement or by usage, if the usage by be such as to bind both the parties. Thus, the contention of the defendant to the effect that since there was no provision for refund of the premium amount in policy document exhibit 3, therefore the defendant was justified in refusing the refund premium amount is not legally tenable. There must be a specific clause to the effect of exhibit 3 in absence there being any specific clause to this effect. Exhibit 3, the defendant is bound to refund the premium amount. Further contention of the defendant is that during the period of insurance, articles were imperiled through the plaintiff did not submit declaration to the effect in terms of declaration clause exhibit 3, but the defendant has not been able to bring on record any evidence to the effect that the insured articles were dispatched. So the negative thing since was not proved, furnished by me, and the same were imperiled during the subsistence of the policy period, it was incumbent upon the defendant to prove that this is as per section 100. So
only the dispatch is important. Imperiled is immaterial.
Yes.
Imperiled is immaterial. Only the dispatch is important.
Dispatch is important for the reason because every time there is a limit of consignment. 100 rupees cover if I am giving, and if I will not know that how much quantity, suppose 11 wagons of 10.
See, I tell you, there are 10 dispatches.
Yes.
If there is no imperilment, after the goods reach the destination, they will say it is not covered by the insurance. The moment there is any problem, they will say it is covered by the insurance. That option, you can exercise any point of time. So this is not the manner in which you can say. And it was never your case that the covered goods were not dispatched.
It is. That is my exact case, Your Ladyship. That the goods covered under this attracting coverage of this policy is not there.
Read your para 7.
Para 17.
Paint ka padhiye para 7.
That as there was no dispatch of material attracting coverage under open general policy, we say that under this policy, no goods were dispatched that attract the terms and conditions of this policy. Your Ladyship. Hence, as for the contract, no declaration was given by the plaintiff to the defendant. That the subject matter insured has never been imperiled, and further no declaration as per the contract was given by the plaintiff to the defendant during the currency of the policy contract, and
The
therefore
declaration does not call for any declaration of impediment. It only talks about
Dispatch.
declaration of dispatch. So your entire case, even from your angle, you say that no declaration was given because there was no imperilment. It is, the declaration is not related to imperilment.
yes, Your Ladyship.
Declaration is of dispatch.
I understand. I only
Then-
may be permitted to read para 5 of my deposition, Your Ladyship. And thereafter, what para 13 and 14 they have relied, para 15 maybe. Only these two paragraphs. Para 5 I say, chunki upyog.
Therefore he is saying that the question of law so formulated is not a substantial question of law. It is essentially interpretation of contract and appreciation of evidences based on record. That is the reason he is raising a very serious objection, which he has got a right to raise under section 100. Now you tell us, is it a pure substantial question of law? Or is it even a question of law? Or it is totally dependent upon the interpretation of the contract and the interpretation of the evidences and the pleadings of the parties? It is not something which is a pure substantial question of law which is coming out of the findings recorded by the applicant. This is what he is raising. बहुत दुखी है इस बात से कि आपको इतना हम सुन
नहीं, ऐसा नहीं है. I don't have personal remarks against it. But all I mean to say is, I would cite that if the question is not substantial, it should not be answered in a second.
that objection he has got. He has been raising this objection right from the date we have framed, because we did not hear him. I remember we did not hear him at the time of framing of the substantial question of law, since he was on case. Rather, his appearance is just recorded, but it is not recorded that heard the counsel for the parties. It's not
No,
that.
their appearance, and since I am already appearing for final disposal, that is beyond.
So it requires
49,
complete
49.
reappreciation of materials on that. It is not a substantial question of fact. And appellate court का finding क्या है?
Appellate court final.
और आप लोग 3 लाख रुपए के लिए लड़ रहे हैं। ये यहाँ पर
No, may I say, apart from the terms, they will also. Somebody was charge sheeted because it was the duty of the officer to submit their BCCL officer fortnight report to us.
which he did
Some peril has happened, they could not claim it. When it was turned out, then somebody has said कि नहीं डाल दो अपना justice. This is the story. The first appellate courts has given finding at para 11. Sorry,
We are
running
not
page-
swayed about
Yes,
by
yes,
that.
not for that.
हमको
It's
नहीं
just
दिखाई
a story.
सुनाई भी नहीं दिया।
It's just a story I said. Why it is. Para running page 11, appellate court, para
Just a
40.
moment.
Point of determination number 2.
Yes, 14.
Yes, para 40, running page 11. Whether Mrs. BCCL respondent here is entitled for refund amount of insurance. Now, as per the pleading, plaintiff concluded one open insurance policy, open special declaration policy in land for incoming stores consignment for all areas of BCCL. A premium of rupees such and such was paid to the defendant by check number such and such, and after realization of the check, amount of policy number such and such dated 27/4/2005 was issued for the period 27/4/2005 to 26/4/2006. It is stated in para 6 of the claim that the said policy contains a declaration clause which says that the insured, here the typographical mistake, plate में insured है, not insurer. Here it is written insurer. The insured will record full particulars of each dispatch in a declaration statement in a chronological order, assigning declaration number for each such dispatch, and a copy of statement should be posted to the company for every fortnight. It is a clear case of plaintiff that since no material was dispatched under the policy, therefore no declaration was given to the defendant during the period of insurance policy. It is further stated that since the insured subject matter was never put at risk and no declaration was given by the plaintiff to the defendant, therefore the plaintiff is entitled to return/refund of the premium amount. The defense taken by the defendant is that there is no provision to refund the premium amount. One pre-Ranjan was produced as PW1 on behalf of the plaintiff, who stated in his evidence by way of affidavit that he is presently employed in head office of BCCL and authorized for the purpose of adducing evidence. However, no such authority was ever produced or got exhibited during the course of trial. PW1 reiterated the contents of the plaint in his affidavit. PW1 was also subjected to cross-examination. In para 13 of cross-examination, he admitted that दिनांक 27/4/2005 से 26/4/2005 के बीच मेरा सामान का स्थानांतरण एक जगह से दूसरी जगह हुआ. In para 14 he stated that BCCL हेडक्वार्टर में डिस्पैच कागजात है इसी पॉलिसी पीरियड के अंदर जिससे पता चलेगा कि कितना डिस्पैच हुआ वह न्यायालय में दाखिल कर सकता हूं. In view of para 13 above, it stands clear that during the policy period goods were transferred from one place to another. It is an admitted fact that the policy contains a declaration clause which provides that the insurer will record full particulars of each dispatch in a declaration statement in chronological order, assigning declaration number for each dispatch, and a copy of statement has to be posted to the insurance company within stipulated time. But the plaintiff company has taken the stand that since goods were not dispatched, therefore no declaration was given to the insurance company. Whereas version of PW2 is contrary to the stand taken by the plaintiff, which leaves no manner of doubt that the goods were dispatched during the policy period, meaning thereby goods were put at the risk, and in that eventuality declaration statement for each statement with minute details was required to be sent to the insurance company, which has not been complied with. Further, para 14 of the cross-examination, PW2 stated that dispatch documents are kept at BCCL headquarters, and by which it will be shown that how many times goods were dispatched. This part of cross-examination leaves no doubt that in fact goods were dispatched during the relevant period, and all dispatch documents are lying with the plaintiff company. But the same were retained in order to justify the claim of the plaintiff company. In view of the above, I may say that the plaintiff has not approached the court with clean hand and suppressed the material in fact so as to decide the real controversy between the parties. As far as question of refund of premium is concerned, there is an absolutely no stipulation in the insurance policy for return/refund of the same. In absence of any agreement in this regard, the claim of the plaintiff company cannot be entertained. It would not be out of place to mention that.
There is no substantial question of law with regard to this finding.
Yes.
There is no substantial question of law with regard to this finding. That your claim is not covered by, since there is no clause of refund under the agreement, therefore the refund cannot come to you, and even under section 84. There is no substantial question of law to that effect. So irrespective of the fact whether you are entitled or not entitled, under the transactions which had happened, there is no provision for refund.
Issue number 5 was, is the premium amount in question returnable by the defendant to the plaintiff?
That is not the substantial question of law. Take a look here. With respect to the third substantial question of law, the learned counsel for the respondent has raised a serious objection and has submitted that the third substantial question of law does not arise for consideration in this case, as the same is not a substantial question of law at all. The learned counsel submits that the learned first appellate court has considered the agreement, terms and conditions of the agreement, and the evidence on record.
Para 6 of plate and para
Terms and conditions of the agreement, the plaint, and the oral evidences
Yes.
on record, oral and documentary evidences on record, to come to a finding that the plaintiff was not entitled for any refund of premium. The learned counsel has also submitted that admittedly there is no clause or stipulation for return of the premium in the agreement between the parties, and the learned first appellate court has recorded that in absence of any such clause, section 84B of the Marine Insurance Act 1963 would not come to the rescue of the plaintiff. The learned counsel submits that with respect to the interpretation of the terms and conditions of agreement read with the interpretation of section 84 with the bracket B of the Marine Insurance Act 1963, no substantial question of law has been framed, and therefore such finding has become final.
the judgment on any like
The learned counsel has submitted that such objection with regard to formation of substantial question of law can be taken by the respondent in terms of section
100 clause
100 with the
Subsection
bracket
5.
3, subsection 5,
That is quoted in this judgment, ladyship.
subsection 5 of
CPC.
CPC, and for that he has referred to the judgment passed by the Honorable Supreme Court reported in bracket 2008 bracket close 12 SCC 796.
Ladyship, second page, page 798, the section is provided. This section 100 is quoted at paragraph 2,
Yes.
and then I am not reading much. 2, 3, 4, I am skipping 5. This appeal shall be heard on the question so formulated, and the respondent shall, at the time of hearing of appeal, be allowed to argue that the case does not involve such question, that there is no substantial question of law. Now the ladyship will kindly come to paragraph 3.
Yes.
There are 4-5 paragraphs I will read. After the amendment, a second appeal can be filed only if substantial question of law is involved in this case. The memorandum of appeal must precisely state the substantial question of law involved, and the High Court is obliged to satisfy itself regarding the existence of such a question. If satisfied, the High Court has to formulate substantial question of law involved in the case. The appeal is required to be heard on the question so formulated. However, the respondent at the time of hearing of appeal has a right to argue that the case in the court did not involve any substantial question of law. The proviso to the section acknowledges the power of the High Court to hear an appeal on a substantial point of law, though not formulated by it with an object to ensuring that no injustice is done to the litigants where such a question was not formulated at the time of admission, either by mistake or by the inadvertence. Then at page 800, paragraph 20, the question of law raised will not be considered as substantial question of law. Paragraph 20. Page 800, paragraph 20. The question of law raised will not be considered as substantial question of law if it stands already decided by the larger bench of the High Court, concerned, or by the Privy Council, or by the Federal Court, or by the Supreme Court. Where the fact requires for a point of law have not been pleaded, a litigant should not be allowed. This is my first. That they have not pleaded, now they are arguing. where the facts required for a point of law have not been pleaded, a litigant should not be allowed to raise the court as a substantial portion of law in a second appeal. So it was never the pleading, now it has become argument. Next, the mere appreciation of fact, the documentary evidence or a meaning of entry and the contents of the document cannot be held to be raising a substantial question of law. But where it is found that the first appellate court has assumed jurisdiction which did not vested in it, the same can be adjudicated in second appeal. It is not the case that it was the incompetent court treating a substantial question law. Where the first appellate court is shown to have exercised its discretion in a judicial manner, it cannot be termed to be an error either in law or in a procedure requiring interference in the second appeal. Next, paragraph 21. The phrase substantial question of law as occurring in amended section 100 CPC is not defined in the code. The word substantial as qualifying question of law means having substance, essential, real or sound worth, important or considerable. It is to be understood as something is in
We need not go to this section, this much is sufficient. Para
Yes.
20 should be sufficient.
yes. With that.
This is a quotation of which judgment?
That
Kanhaiya Lal.
yes.
Versus
Paragraph
Anup
is
Kumar.
2003-1 SCC 430. And
The learned counsel has further referred to
sorry, Bishop, it is in the court of Chunilal Mehta versus Sons Limited. That is page 800. It is two judgments. That is one is of AIR 1962 Supreme Court and the another is 2003-1 SCC 430.
this paragraph, you see, internal page 799.
799.
The position has been reiterated in Kanhaiya Lal versus Anup.
Yes, that starts from here. And then
Paragraphing is-
yes, you can say 1789. So again, it's
This is
67
Kanhaiya
is
Lal.
quoted there. 67 is quoted inside that. So one judgment will serve.
The learned counsel has referred to internal page 799 of the aforesaid report and has submitted that paragraph 17 onwards of the earlier judgment passed in the case of Kanhaiya Lal Anup Kumar reported in bracket 2003 bracket code 1 SCC 430 has been considered, and in particular he has referred to paragraph 20 thereof to submit that where the facts required for a point of law have not been pleaded, a litigant should not be allowed to raise that question as a substantial question of law in second appeal. He has also submitted that mere appreciation of facts, it has been held in the same paragraph itself that mere appreciation of facts, the documentary evidences or the meaning of the entries and the contents of the documents cannot be held to be raising a substantial question of law. The learned counsel submits that in order to answer the substantial question of law so framed by this court, in paragraph 5 within bracket C of the order dated 29/4/2025, the same essentially requires appreciation of pleadings and evidences on record and interpretation of the documents, which has already been fairly done by the learned first appellate court. आपको क्या बोलना है इसमें? Can you argue this substantial question of law without referring to the evidences on record?
Your Lordship, I can argue, but my only contention was that they have not brought on record any proof showing that the goods were dispatched. They have relied upon my statement. They have gone ahead and said that there is no clause for refund of the policy. But the offer that I
No,
had made.
refund, that is not the substantial question of law claim. We will not go into
And
that.
if they are only going into the deposition that I have made, then my deposition para 5 and reassertion of the para 5 in para 15 of the cross examination should be looked into. Because I have said that there was no dispatch.
The learned counsel for the appellant in response has submitted that it was the specific case of the plaintiff that there was no dispatch covered under the policy. There may be dispatches, but unless the dispatch is covered under the policy, the insurance policy, there was no requirement to give any details of such dispatch, and therefore the learned first appellate court has not considered the matter properly while reversing the decree. Right?
And apart from that, the doctrine of contra pro that I want to state.
What is that?
Under para 53, 46.1, para 53 talks about doctrine of contra profantem rule. In page 736, para 46.1 says, in General Assurance Society Limited versus Chandumul Jain, it was held that where there is an ambiguity in the contract of insurance or doubt, it has to be construed contra profantem against the insurance company.
That was not their case in plate.
Which paragraph are you reading?
Para 7, page 736, your Lordship. Para 53, under that there is 46, sub para 46, 46.1. That if there is,
Okay. The learned counsel for the appellant has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2024, bracket code 8 SCC 712, paragraph 53, which deals with the doctrine of contra proferentum rule, and she submits that in the same paragraph, a reference has been made to the judgment passed by the Honorable Supreme Court reported in AIR 1966 SC 1644 within bracket General Assurance Society Limited versus Chandumul Jain, wherein it was held that where there is an ambiguity in the contract of insurance or doubt, it has to be construed contra profantem against the insurance company. The learned counsel submits that this principle is attracted in the present case, and there is ambiguity in the terms and conditions of the policy, and therefore the impugned judgment is fit to be set aside. In response, the learned counsel for the respondent has submitted that it was never the case of the plaintiff that one or the other clause of the contract or insurance was suffering from any doubt or ambiguity.
Your Lordship, in their written statement, they have stated that there is no refund policy.
That's all about the
My only submission.
And therefore, such principle is not attracted, and consequently, the judgment relied upon by the appellant has no applicability to the facts.
Only my last submission, section 58 of the Evidence Act.
He has referred to section 58 of the
58 and
Evidence Act.
103.
58 and
58 and 103. Section 58
103.
says, Section 58 says, fact admitted need not be proved. Here, last line will come to be. No fact needed to be proved in any proceeding which parties thereto or their agents agree to admit at hearing, or which before hearing they agree to admit by any writing under this hand, or which by any rule of pleading in force at the time they are deemed to have been admitted in their pleading. So whatever plaint is there is their own admission, and contrary I am not required to be proved, and therefore question number C, that whether it was onus upon me, is against section 58 and 103. This is different.
The Learned Counsel has further referred to Section 58 of the Indian Evidence Act and Section 103 of the said Act, and has submitted that the whatever pleading was there in the plaint on behalf of the plaintiff was only required to be addressed, and therefore there was no burden of proof with regard to dispatch of insured article by the plaintiff.
Is upon me.
There was no burden of proof on the defendant to prove dispatch of insured articles by the plaintiff during the insurance period. The Learned Counsel submits that the Learned First Appellate Court has interpreted the contract by holding that each and every dispatch was to be disclosed.
Last section
92.
because they have said that oral evidence something they have explained that cannot be. Section 92. Exclusion of evidence of oral evidence. 92.
The Learned Counsel has also submitted that when the terms of the contract was clear,
Is in writing.
when the terms of the contract is in writing, then the
No
same
contrary.
cannot be interpreted through oral evidence.
Yes.
Right?
Yes.
After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the parties were bound by the insurance policy covered under the Marine Insurance Act 1963, which was valid for a period from 27/4/2005 to 26/4/2006. It is further not in dispute that after the period of insurance was over, the plaintiff had applied for refund of the premium, to which the defendant had denied, while communication dated 26/12/2006, and the same was under the same was drawing kind attention to Mr. Mihir Chandra within bracket materials manager within bracket SD. A legal notice was also given by the plaintiff dated 20th of March 2007, seeking refund of rupees 2,75,501 through registered post, but the plaintiff did not receive any response to the same. The legal notice is Exhibit 6. The aforesaid communication dated 26/12/2006 refusing to refund is Exhibit 5. The payment of premium through check amounting to rupees 2,75,501 is Exhibit 4. The Exhibit 1 is the communication issued by the defendant, issued by the plaintiff to the defendant regarding acceptance of policy, that is dated 3/3/2005. Exhibit 2 is the general terms and conditions. 2 and 3 are the documents connecting general terms and conditions of the policy. The documents were marked without objection from the side of the defendant. And thus the documents by itself are not in dispute. So far as the first and second, this court finds that a suit was filed having on account of refusal to refund the premium amount and having no response to the legal notice, a suit was filed. A money suit was filed seeking recovery of rupees 2,75,501 with interest pendentialite and future. The defendants appeared and filed their written statement opposing the prayer. Following issues were framed for consideration. Para 5 se lenge. The learned trial court considered all the issues and were decided in favor of the plaintiff, all the issues. And decreed the suit. So far as the learned first appellate court is concerned, it framed 3 points for determination, which are as follows. Para 12. All the points for determination were decided against the plaintiff and in favor of the defendant, and consequently, the judgment and decree passed by the learned trial court was executed.
Section 126 was decided in my favor. 7 it said that there is no, so far as it is concerned, having regards to the facts and circumstances and also having regard to the evidence, it is not just and proper to grant any other relief to the plaintiff. Very
7 was just following. All the material issues were decided by the learned trial court in favor of the plaintiff. So far as the first and second substantial question of law is concerned, they are related, and counsel for the parties have advanced their arguments with respect to both the issues at one go. This court finds that the plaint was filed by the plaintiff namely Mrs. Bharat Coking Coal Limited, and stating that the plaintiff is a company within the is a central government company within the meaning of section 617 of the Indian Companies Act, having its registered office at Dhanbad, and it was accompanied with verification and affidavit. The plaint was verified by one Priya Ranjan, who was the employee of the plaintiff company, posted at BCCL headquarters as material manager, and claimed to have been authorized to file the suit, and also claimed that he was well acquainted with the facts and circumstances of the case. The body of the plaint as such did not mention about the status of Priya Ranjan, but the plaint was duly signed, verified and affidavitted by Priya Ranjan, declaring his status and also acquaintance and authority to file the case. The written statement was filed by the defendant, raising that the suit was not maintainable either in law or on fact. And further, no objection was raised with regard to the locus/status or authority of Priya Ranjan to file the suit. In such circumstances, the learned trial court, apart from formulating a formal issue as issue number 1 as to whether the suit as framed was legally maintainable, no issue was framed with regard to competence of Priya Ranjan to file the suit. While deciding issue number 1, the learned trial court held that the suit was maintainable as the refund for payment of premium was denied by the defendant and there was valid cause of action. The records of the case reveal that the plaintiff and the defendant did not join issue with regard to the locus of Priya Ranjan to file the case on behalf of the plaintiff, namely Mrs. Bharat Coking Coal Limited. The respondent has submitted that since there was no averment in the plaint, in the body of the plaint as such, regarding the status and locus of Priyaranjan to file the suit, so no such specific averment was made in the written statement. This court, he has also submitted that the verification and affidavit do not form part of the plaint. This court is of the considered view that the plaint has to be seen along with its verification and affidavit, and the argument of the learned counsel for the respondent that affidavit which formed an integral part of the plaint had no value at all is not tenable in the eyes of law. This court is further finds that in under order 20, this court further finds that the learned counsel for the respondent has also submitted that the court can suo motu go into the maintainability of the suit as filed, and therefore he has submitted that there was no illegality on the part of the learned first appellate court in framing an issue to that effect. He has also relied upon the provisions under the Limitation Act to submit that the courts are suo motu are under obligation to examine the point of limitation. Similar is the situation with respect to the person who is filing the plaint. This court is of the view that the Order 29 Rule 1 clearly provides that in case of corporation, the suit can be filed by secretary or any director or any other principal officer of the corporation who is able to depose to the facts of the case. This court is of the view that the law clearly provides that any principal officer of the corporation who is able to depose to the facts is competent to file the suit. And the affidavit appended to the plaint clearly indicated that Priyaranjan was authorized and was well acquainted with the facts and circumstances of the case. The statements made in affidavit to the plaint are not ornamental, but every word carries meaning in it. The term principal officer as such has not been defined under the CPC. The judgments which has been relied upon by the learned counsel for the appellant with respect to the authority of principal officer of the corporation to file the plaint and depose essentially reveal that whether a person would constitute to be, would qualify to be a principal officer of the company would essentially depend upon the facts and circumstances of the case, and it is essentially a matter of evidence. This court is of the view that since no serious objection was taken on the part of the defendant with regard to the status of the Priyaranjan to file the suit. There was no occasion for him to bring home through evidence regarding his acquaintance with the facts and circumstances of the case and the fact that he would qualify as a principal officer. The aforesaid judgment also revealed that there is also a possibility of post facto approval by the company. If any such objection was raised by the defendant, then there was also a scope for post facto approval by the company. Such objection having not been raised at appropriate time, there was no occasion to even go for post facto approval. The evidence on affidavit which was filed by Priyaranjan also reveals that he made a statement that he was acquainted with the facts and circumstances of the case to depose. And there is no cross-examination from the side of the defendant with regard to the competence of Priyaranjan to file the plaint and depose on behalf of the plaintiff. So far as the analogy having been drawn by the respondent with regard to the provision of Limitation Act, this court finds that under Section 3 of the Limitation Act, there is a legal obligation cast on every court to see as to suo motu, even to suo motu see as to whether the suit is barred by limitation. This court is of the view that in case where the law permits the plaint to be filed even by the principal officer, and in case where no specific objection has been raised by the defendant with regard to the locus of the principal office, the officer who had filed the case, the parties do not join issue on such matter, and therefore there was no occasion for the learned first appellate court to frame a point for determination in that direction. The locus of Priyaranjan to file the case was itself would have been a matter of mixed question of fact and law had the defendant raised such an issue at the stage of trial. In view of the aforesaid findings, this court is of the view that the learned first appellate court was not justified in framing the point of determination, number one, that is whether the suit has been signed, verified and instituted by a duly authorized person, in spite of there being no specific objection from the side of the defendant on this ground. So far as the first substantial question of law, further this court finds, it also holds that the finding of the learned first appellate court that suit was not signed, verified and instituted by a duly authorized person is itself perverse on the face of the affidavit appended to the plaint. Accordingly, both substantial question of law number A and B, first nailed at the A and B letter, are answered in favor of the appellant and against the respondents. so far as the third substantial question of law is concerned, the learned counsel for the respondents has raised a serious objection by stating that the same is not a substantial question of law at all. And for that, he has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2008, bracket 12, SCC 796. The third substantial question of law essentially deals with the burden of proof with regard to dispatch of insured articles by the plaintiff, dispatch of insured articles upon the defendant when the plaintiff had taken a plea that plaintiff had not dispatched the insured articles during the period. This court finds that the specific case of the plaintiff as per paragraph 6, 7 and 8 of the plaint was that besides other condition, there was a declaration clause and it was their case that there was no dispatch of material attracting coverage under open general policy, and therefore no declaration was given by the plaintiff to the defendant during the currency of contract. It was their further case that the subject matter insured had never been imperiled and no further declaration as per the contract was given by the plaintiff to the defendant during the currency of the policy, and therefore the entire premium amount was refunded. From the perusal of the entire plaint, this court finds that no plea was raised by the plaintiff that one or the other clause was ambiguous so as to attract the principle of contra profrentum, and therefore the judgment as relied upon by the appellant reported in bracket 2024 bracket 8 SCC 712 does not apply to the facts and circumstances of this case. This court finds that admittedly no declaration was furnished from the side of the plaintiff, and they claimed that the dispatched material, that there was no dispatched material attracting coverage under open general policy. Although as per the declaration clause, the insured was required to give full particulars of each dispatch to underline in a declaration statement. In the chronological order, assigning declaration number for each such dispatch. This clause has been interpreted by the learned first appellate court by holding that each and every dispatch was required to be interpreted. And during the cross-examination of PW1, he has admitted that there were numerous dispatches during the period in question in paragraph 13 and 14 of the evidence. And in paragraph 5, he has stated that the period that the dispatch covering the insurance were not available. Yeah, yeah, na? There was no dispatch covering the insurance. This would
reiterated the same in paragraph 15.
yes. Both the councils have referred to the evidences on record and also the terms and conditions of the agreement and have advanced their argument to with respect to the third substantial question of law. This court finds that the learned first appellate court has appreciated the plain written statement, the terms and conditions of the agreement, and has come to a definite finding upon interpretation of clause 6 that all the full particulars of each dispatch in the declaration was to be given. In such circumstances, as per the learned first appellate court, the onus was upon the plaintiff to make declaration of each and every dispatch which the plaintiff admittedly failed to abide by. And therefore, this court is fully satisfied with the arguments advanced on behalf of the respondent that the third substantial question of law as framed by this court is not a substantial question of law, as the same would involve interpretation of the agreement, the evidences on record, and no perversity as such has been shown by the learned counsel for the appellant with respect to the appreciation of evidences and materials placed on record. This is over and above the fact that the learned first appellate court has recorded a clear finding that section 83 (b) of the Marine Insurance Act is not attracted, as the terms and conditions of the contract did not have any such clause to entitle the
plaintiff to claim refund from the
plaintiff to claim refund
of
of
premium
premium.
from the defendant.
This court finds that no substantial question of law has been framed with regard to such finding of the learned first appellate. In view of the aforesaid facts and circumstances, having held that the third substantial question of law, as framed by this court, is not a substantial question of law in the eyes of section 100 of CPC, this court is not inclined to answer the same. और तो कुछ नहीं आंसर करना होगा, जब नहीं है तो नहीं आंसर करना है.
And therefore, second appeal will be dismissed because
It's
it's
certainly
substantial.
dismissed. And consequently, the second appeal is hereby dismissed.
Your Worship, first and second have been answered in my
So
favor.
even if,
So what?
even
was
if
maintainable.
allowed, you are not entitled.
I don't say that it was not maintained. क्या करें? नहीं, अब एक second. In spite of holding that the second substantial question of law is answered in favor of the appellant, in view of the aforesaid finding of this court that the third substantial question of law is not a substantial question of law, the findings recorded by the learned first appellate court that the plaintiff is not entitled for the refund does not call for any defense. Consequently, the suit which has been dismissed on merit, the suit which has been
Allowed on merits, dismissed on
appeal.
appeal.
Okay. The consequently the decree, consequently the suit which has been
It's consequently the
The-
order
the-
of
the
the
suit-
first appellate court is hereby confirmed. That
and yes,
first appellate
consequently the judgment of the first appellate court is confirmed except with regard to point of determination number 1.
Yes.
Okay,
Determination number 1. Yes.
number 1.
Yes.
Corrections होगा, quotations होगा.
Yeah. May I submit on the that particular judgment says that the Honorable High Court can see and can answer this question first itself and then can decline to answer rest.
That is also a matter of public importance. कि कैसे सूट फाइल होगा, कैसे क्या होगा. We are finding numerous instances as to how anybody is coming and filing the suit. अभी तक ऐसा नहीं मिला है जहाँ वो बोल रहा है, कंपनी बोल रहा है I disown the suit. ऐसा नहीं मिला अभी तक, but it is quite possible.
Yes, because once liability will come, then they will say no, it's not binding.
अभी तक ऐसा इंस्टेंस नहीं आया है, आर्बिट्रेशन में भी नहीं देखे हैं.
Anyway, it was my duty to review.